Mm-hmm. Okay. All right, we're live. Let me connect to the stream. Wait. Okay, I'm gonna go out there and see if I hear anything. Okay.
2 minutes.
If it still doesn't work after she tests that, let's try plugging in the Black Magic.
Yes, it is.
300%.
You're supposed to bring that. Did you not grab that?
Just say yes, I did it. Lala, there's no straight cast.
We can still do the DJI and do Black Magic. It might process it differently.
I don't have time.
They won't come there. They're like, hey, this is just a quarter mile away.
Ricky's our newest commissioner of Big City.
Yeah, right.
So he made the big track for us.
You barely hear it. You can barely hear it. I hear it in my headphones. But
Just the camera audio? Or?
I can hear myself talk.
Okay, so it's picking up.
But how do we get it to pick up from not the computer?
Which group is more fun? Segregating I'm here live. I was going live.
I'm gonna try plugging it into here, see if it'll pick anything up, which I'm not sure if it will or not. Okay. Okay, I'm just gonna plug this for just 3 seconds. Okay, is anything different happening at all? Let's see on the screen. The game must be turned up or something.
You want to try the Black Magic?
You don't have time, yo.
Hey, buddy boy. Doing all right?
Good.
Good to see you.
Just trying to figure out this sound.
Yeah, no worries, no worries. I know you guys will figure it out, so I'm not worried.
Because I'm just wondering if the Lumix is having an issue with its HDMI output as well.
Turn your camera on. Let's try. It's at this point. Now does the tether will the tether work for this?
No, we don't need tether. Do you still have the tether open?
Yes.
That might be the issue then,
Is that
because
the
the
issue?
tether wasn't doing audio.
Okay. So,
I didn't know you still had the tether open.
Yeah. So.
Yeah, so that you just need to do the input from the capture card. That's why I was saying we're not going to use tether, and we needed the capture card, because Jack was running into the issue of tether wasn't providing audio.
Okay, so this is plugged in now. So did you set the capture up here?
Canon?
Okay.
Noltons?
Media
This is
source.
Lumix Panasonic.
Okay. Video capture device.
Yep.
Okay. Okay. Let's do it. Device. Why is it saying that? Okay, it's saying this. Should it?
Device, HP, video, vision.
You're in this is supposed to be output, isn't it?
Well, input is coming from the camera into there, which is coming into here.
Yeah.
Is that correct?
Yeah, this is the video input.
Right.
The output would be to like a separate monitor or something.
Okay. So it's not showing up for some reason.
Just click it. Just
There might be something wrong with
Get your camera down.
my camera. No, I'm saying because it seems like it's not even picking up this as a.
Media source. Let's see. It's not, this didn't even pop up on my computer when I plugged it in. So,
Let's switch the cable out. Let's unplug it from here for just a minute.
Hi, how are you? Good to see you. Likewise. Likewise. Are we good, do you think, guys?
we're having issues with getting the audio to play correctly onto the YouTube streaming. So let's see here. We're trying to problem solve.
Do you want one of those hearing aid microphones for that help? Do you want to try that?
That might have to be on one of those.
If you want to, do you want me to go grab one and then bring it over? All right.
Thank you.
Sure.
It's not moving from this either. Because should this be like popping up on my camera? I mean, this is red right now.
Well, it should just be providing a video input. Like you should be able to. How do we select?
Do that for video capture device, and it should.
Yeah, video capture device.
Just press OK. And then device, like we should. Okay, USB
pick
video.
up.
Oh my gosh.
Thank you.
Okay. This one too. Well, this isn't plugged in. Where do I have it? Right here. Okay. So if this is plugged into here. This one too.
Here is this
Are
one.
we gonna hear it? Hold on a sec.
Hang on. Let me squeeze by you real quick.
Okay.
Thank you so much.
If you don't, no worries.
Really appreciate it. Okay.
We're gonna plug this in here.
Okay. Okay. Plug it in. Okay. So.
We're golden. We're golden.
Where are we picking it up?
Right there.
Right.
Oh my god. Go, 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 go. Start the freaking stream.
That was the issue. I was like, what's going on?
11. That's that. Never again.
You can hear the audio from the stream.
It's perfect.
It's perfect.
Everything's working.
It's working.
It's
Okay.
working.
Do we need to help them get set up with the stream in the other rooms?
I don't think so because it's just a YouTube link. So I
No, I know.
see 11.
Don't they need the YouTube link?
They have it. I've already emailed it to them.
Oh, okay.
There's already they're watching. Everybody's watching. So.
So we need to do an audio test. So they're going to be talking back and forth.
Yes.
So if I'm standing here and then if someone else is talking, will you be able to hear me? So put the headphones on and I'm going to do a test and then Danielle? Yes. Okay. Then Danielle's going to say a few words and see if...
Why are you switching? Why are you switching?
Because I was plugged into the capture card. So I just want to make sure.
Can you hear me? Test 1, 2. 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 Picking anything up? Are we hearing anything?
Yeah, I'm hearing you.
You hear me? Test 1, 2. Test 1, 2.
Go, check.
We're hearing it. Oh, it's just extremely, it's delayed. That's why we're not hearing it. It's delayed.
So
Yeah, that's why we were listening for.
Yeah.
Do we need a mic or?
Let's go ahead and mic her up, and then I'll adjust the gain so it's really high, and then just try not to scream all of a sudden. Okay, that will work.
And you said there's one more mic?
We have another mic. Is there another speaker that will be like talking at all times?
Kirsten.
Will she be up there a lot?
Yes.
Okay.
Positioning is good. Camera.
Yeah, we have the
I'm
floor
gonna-
taped off.
I'm gonna run upstairs and see if they're good.
Okay.
So we
Okay.
good, Gucci. Are we recording? We need to be recording.
Well, the YouTube will record
It is.
Yeah,
it
we'll
is-
record it.
No, it will not. Well, that.
Okay. Start
Oh,
recording.
okay.
Yes.
Okay.
once we start.
I'd say let's just do it now. So remember, everything's recorded. So whatever. So. Again, we're solid, right? Everything's-
Let me put this on my. Right now.
We're live. Rolling live. Good.
All right, we're going to go ahead and get started. Hopefully, upstairs rooms are through this. And we will take a second and just make sure the Zoom that you're through this and that everything is going. And then also up in my office, please. Thank you. All right, so it's working. So all good. Well, I thought what we'd do is introduce the crew to you. Most everybody I'll introduce works in the municipal law side of things. The first person I'm going to introduce is my cohort. We crossed swords probably for about 20 years, I suppose. We have always been
There's no
and he was annexed into the and I was
There's no
trying to get a cement plant site. And that,
You just
So we did this.
Is it just in one room? Or
It's
all?
in both rooms.
Both rooms. They can hear. Okay.
We're just doing introductions right now, so we can just go forward with introductions, and then you can do that. But this is David Wagner. When he was retired and he was a county attorney, he said there was two
Send that link.
stipulations now. First of all,
Yeah.
I've been
Were they good up there?
No.
No.
Email it to me.
in West Virginia since I was 16 years old. I'm not going to punch clock. So that's not your purpose. Your purpose is to mentor the younger lawyers. And I said, what's your stipulation number 2? He said, I'm not going to be a city commissioner. He's not going to do it.
Oh, the old stream.
Especially at night. So
Right,
you
'cause we
won't
did
see
put
him
the
at the
stream
cities,
together.
but he's
Okay.
around here and he helps us tremendously with issues. He's seen a lot of legal issues over the years and he's tremendously helpful to us in that regard. So David's invaluable to us. And then what I thought we'd do is just talk about what you can introduce yourselves and what you do in the long run.
I can.
If you're involved in the legal process.
I'm Derek Holtz. I'm an associate attorney here since 2016. I am the daughter of Allison Holtz. I don't go to the city meetings or the city board, but I do appeals. So if there's any appellate issues, then I'm involved in that aspect.
She's an editor of her law review, and she is a tremendous writer. She has tremendous analytical skills, and it takes a special lawyer to write appellate briefs and to argue. That is a forte area that she has. She also assists in litigation, and she's tremendous good lawyer as well. So she's really helpful. So, Jean, so let's stop at the front desk. Jean will direct you, and she'll take a message if need be. But she comes to us. What you look at finance
Did you just send it? I just sent it to you again. Did you get that?
No, they have it upstairs. They can't see it.
I just sent it.
Low volume.
The audio doesn't sound like it's coming from the DJI.
I work primarily with City of High Springs, City of Lake City, and now
Um,
Sounds like it's coming from a stuff.
so I am here. I don't know where Kristen.
where's the other? What's the tab? We're troubleshooting. Yeah, we're troubleshooting.
So the people in the community that are in Tony, I'm sure a lot of you know me. My name is
Why is he picking up on video?
Walker.
Seems to
2021.
be a pattern.
And I used to stay on the screen a year ago.
You can try that now.
Well, the pattern that we have is we get to study you and how you do as a law clerk, and then vice versa, they say, okay, is this a fit? Danielle went to American University in law school, and interestingly, she had a law firm that she was working with. And just like you, Lisa, hey,
Waiting.
doors open here. We want you, we need you, and we would love to have you. So that's an example of what we're saying. Adam, come on. Adam Victoria. Just finished first semester of my third year, so hopefully we'll finish. And then plan is to graduate in July and get a big boy job working in the ACA. So here I work on legal research, where a lot of the questions that you ask the attorneys, different drafting, any types of real important things, legalizing, and any type of general legal things that you do a little bit of law school experience. And Ross, we told him about Northern Maine, and Ross grew up in Michigan, went to King College, Kalamazoo. He definitely for the winters here, summers in Chicago are hard to do. Winters here are better. Summers and counties are two good things in Chicago. But to me, it's easy to take. We're doing it up. I'm from Mark. Been with Thornhill since 2016. Primarily, I handle the city of Stock and city of Hartford. Anything real estate related, I'm probably involved in the background for all of our cities. So maybe I'm from there, but that's another role we play. And recently, I guess, with Infosys, but I'm primarily handling real estate transactions for the firm. I took them off for the last month or so. They were kind of not so good a few months ago. Beyond that, I'm homegrown and a lot of the county resident and relations. Trying to keep my goals here. The next generation more beyond that. Establish some roots.
He helped. Clay was interesting. He was in politics before he started off practicing law, then got heavily into politics, helped Ted Yoho get elected. He was on the campaign manager for Ted, and also Adam Putnam. So he was instrumental in that. I think Ted saw what he did for Adam and said, "Hey, come help me with this sort of thing." And then he decided that Washington, D.C. was not his cup of tea and wanted to come back to practice law in Alachua County. And we said, "Good, we need you, we want you as well." So, Crystal, why don't you introduce yourself?
I am Crystal Ross, and I'm a new addition to the firm as well. And I am the legal assistant for Mr. Scott Walker and Miss Danielle Adams. I also handle all of the coordinating for city meetings and any other correspondence that you need to make sure gets before these lovely city attorneys. You will send it to me and I will send it out accordingly.
She is a crackerjack, I'll tell you. And you all in Williston already know about her. She is just terrific, and she is one of the real bright spots. And as you know, she always comes with a smile on her face. And you know, when people come to a law office, you've got troubles that you're dealing with mostly, and she has a very positive attitude all the time. So she's a spot of sunshine for us for sure. Lizzie and I think Rebecca, you're around the corner. Who's around the corner? All right, well, come on out and introduce yourselves. Part of this is if you're going to be a lawyer, you have to be used to speaking in front of people. So this is my way of doing that. So you're first. Little did you know you were going to be front and center.
Hi, I'm Rebecca. I'm a legal assistant here at Bolt Walker. Nice to meet you.
And she is relatively new. She's learning all about financial disclosures. She's going to be our go-to lady for all of that kind of thing. She'll help us with city work as needed as well. And she's one of our bright spots.
Thank you.
Lizzie, now we call these folks, we call them clerks, but they're much more than file clerks. And I don't know if Jack's around the corner. Is he? Okay. So Jack, come on. You can go to the second floor if you want to. We'll introduce you in just a second. But we got to get you on the microphone so it sounds like the mics are working. We call them file clerks, but they're much more than file clerks. They do analysis, they do spreadsheets for us, they do all kinds of very intricate work. And they're
You're
really,
getting
really
reverbs
good at
with
it.
the
And
TikTok.
they
If you just turn that one off, that'd be great.
With that, Lizzie, tell us about yourself.
Hi everyone, my name is Lizzie Quintana and I am currently a pre-law student at University of Florida. I've been here for about a year and a half now. I absolutely love it. I've learned a lot and I'm currently applying to law school right now.
Wanted to become a double gator.
Yes,
And
that's the
stick
goal.
around.
That's the
And
goal.
then, as we talked about the pattern of things, you know, she hopefully sticks around here, and then we'll evaluate her, and she us, and we'll have some more needs coming down the pipe. Jack. Why don't you come over here so you can, if we're on, if we're doing that.
Okay, I guess. Hi everyone, my name is Jack Flam. I'm a third year at the University of Florida. I've been working here since May of this year, and I handle the majority of the city file clerk stuff. So if you guys have ever gotten a call to your city clerk office asking to confirm meeting dates 8 times, that was probably me, to make sure that we would all make it there on time, that all the agendas made it there. I've really enjoyed working here, and I'm excited to see what this presentation holds. So
Jack is one of the guys that has helped tremendously in doing spreadsheets and analysis and things like that. So again, call him file clerk, but he's way, way more than that. And these young people are so adept at what they're doing. They're at UF, and you know, I wish I could have been that kind of student when I was there. I mean, they're really, really on a, you know, they're on a path that they're going to do great things in life, in my opinion.
Of the undergraduate trial team here, and they come back from their trial competitions and win something every time they come back here at the office. It's pretty amazing.
Well, Clay, that's right, and these are national competitions, so they're competing against University of Chicago, or they're in all kinds of that kind of level of competition. And Jack, you just took the overall event, I think, in one of those, didn't you? Yeah. Which one was that?
we took the overall event at Duke University, their competition.
Pretty strong, I gotta say. And go UF, go Gators. Where's Sydney? Hey, Allison, come on out. You gotta. He's the guy that started all this. He's the one that built the building, and built it as a law office. And so this is the house that Allison built, and been my partner for pretty close to 40 years. So we've been together ever since I first started.
Huh. Well, I'm the one that got Scott involved in all this, like a long time ago. I started out practicing with O.C. Fagan, and he was the city attorney for the city of Gainesville when they had private attorneys rather than in-house counsel. So for 15 years we did that, and at one time or another, I've represented every city in Watchman County except La Crosse, and several outside. So Scott came in and followed me along with that, and we've kind of been a partnership with that throughout the years, and really consider it an honor to represent the city. It's something that we're chosen, we're dedicated to it, and hopefully we help the cities go through that, and we'll continue. So I've been here a long time. In fact, I went to kindergarten right across the street over here. Back,
He hasn't gotten very far.
Back many years ago. So Scott's a great partner to have. We've been together for 40 years, and I got him into this, and so hope I can keep helping him out.
I think that if you'd asked Allison when he was in law school, would you consider yourself a municipal law attorney, and is that something that he would have said no? And I would have said the same thing, but he loved it, and when he was doing it on a full-time basis, I love it as well, very much.
In fact, my major was in business administration and industrial management, and I was gonna take the easy way out and go to work with my dad in a hardware store, which is right down by the courthouse square. You all seen some pictures out in the lobby of that. So I was originally gonna be a hardware man and still dabble in that and tried to practice law and run a hardware store at the same time, but you can't do that. So thank you again, Scott, for being my partner.
Thank you. Thank you for getting all this started, Allison. I think we're ready to start. Is all the equipment working okay? Are we ready to go?
To my Lake City folks who are watching at home who now can hear us. I just got a text from Audrey Sykes, their clerk, and she was like, I hate that our city missed your introduction. And so here I am to introduce myself again to you guys. The clapping was great the first time around, guys. So, thank you.
She's not too shy, is she?
No, never been shy, never been accused of that. Lake City, Live Oak, thank you guys for tuning in. I'm Danielle Adams. I'm one of your assistant city attorneys. I just started here at the firm a few months ago as an attorney, but I've got a long background as a file clerk and a law clerk, so I've been working on the cities for a long time.
Long time. And you've been working on and putting together these presentations as well, along with Andrea. And we're really blessed and lucky to have Andrea come back for part 2. She's no longer with the firm, but she's working with Sandberg Phoenix, which is a huge law firm out of St. Louis. And she's doing it. And it's a compliment to us and a compliment to her that a large law firm like that took her on. That means that we're hiring people that have talent. And she's definitely, I'll tell you the other thing about Andrea is she's not scared of the fight. She does not back down. I've seen it. We've tried some cases, some heavy cases together. And she may not look at it, but she's a scrapper. I'll tell you. You don't want her on the other side. So, but thank you for coming back.
Absolutely, yeah. I helped with the presentation for about 4 years prior to the last 6 months. So I was happy to come back and see everyone's face and catch up and see the not even new team, but the team keep redeveloping the presentation and making it better every year. So glad to be back.
With that, let's get started.
Let's get started.
Okay, who's presenting first? What's the game plan? All right.
Everyone is going to talk very close to the microphone and away from the television such that there is no reverberation. We like to kick off our ethics training with fun. This is a lot of dry material, so we do try to throw a couple of fun things in here for you all. So Andrea, a few years ago, discovered these young gentlemen named Chad and JT who love going to city commission meetings all over the country and speaking during public comment. And they have a little bit too much fun speaking during public comment, but I'm going to let the video speak for itself.
There is a point to this as well. So sometimes in commissioner comment and citizen comment, say, okay, can we have this go on? And the answer to that is yeah. I mean, it's free speech at its finest. And so no matter what the subject is, you have to allow it as long as it doesn't offend the principles of free speech when it's citizen comment. And that's what Chad and JT do. And to me, it's interesting, but there is a little educational component to it as well.
That's why we keep him around. I'm the fun, he's the brains. So, Kirsten, I'm going to step away with the mic so that we don't get a reverb, but go ahead.
I feel better for a while. The part is really sick though. I feel better for longer. A lot of
Oh, okay. Take the mic so the rest of the folks can hear it.
I partied, and I feel better for a while. Part is really sick though. I feel better for longer. A lot of rages have made me feel really stoked. Characters got playing dandies, phone parties, and volunteers to hockey song. The rages that really make my front peak though, and this is beyond debate, or on a boat. Nothing feels as legit as being on a yacht deck with a linen shirt open. My body tight from a pre-vacay jeans cleanse. What a freaking boost. One thing that bugs me out though is that not everyone gets to participate. Why is it that only people like P. Diddy, Jeff Bezos, and my Uncle Ron get to experience the euphoria of being on a yacht? I think I have the solution. We need public yachts. 60 to 120-foot boats that can be borrowed like books from the library. The boat borrowers would have to do a lot of paperwork, which will blow, but I think it's necessary. With the public yacht program, our countrywide malaise would get sprayed away by jet ski water. Thank you.
What up, Council? I am JT Parr. Chad is not exaggerating when he says that partying on a boat can benefit your soul. I suffer from anxiety. I often worry that my dad thinks I'm a whiner, but those worries disappear when I jump off a yacht's tuna tower. That's why Chad, who is too modest to include his role, set up the boat party. What a legend. That single day partying on the boat reset my brain. We stood on the bow and laughed with some nice girls from Denver. We also made friends with the crew, and I'm eager to read the graphic novel 300 that the first mate Darren loaned me. The benefits from the boat day were immense. That is why I believe, like Chad, that every American should enjoy the right to party on a yacht and or rip on a wave runner. We should be more egalitarian when it comes to boats. We mustn't forget we are Americans. We do big things, like the Transcontinental Railroad or going to the moon. People may ask why public yachts, and I say because there's not a danger idea in the world.
And we can start with Mike's boat. That would be a good starting place.
Yes, Mike New is going to donate his boat for public yacht usage. All right. Okay, so why are we here? Because you have to be. Statute mandates it. Tonight we're going to have 2 hours of ethics, an hour of open meetings, which is sunshine law, and an hour of open records, which are your public records requests. We're going to start off with a little bit of quasi-judicial information because we know that it's in the cities all the time. And a lot of the cities have been looking for some guidance. So it's brief, it won't be too long, but it is going to give you a primer to quasi-judicial. How you will signify that you attended a training. You signed in when you came in. If you did not, please sign in when you leave. We will send out certificates such that it reflects that you were here. And then when you go to fill out your statement of financial interest in July, you will check the box that says, I certify I have completed the required training. Quasi-judicial hearings, Dave Wagner is going to assist me in this. He has been practicing much longer than I have been, by a whopping 3 months. So, what is a quasi-judicial hearing and when does it apply? We typically see it, I'm going to try to stand out of the way so that you all can see. Am I in your way now? I'm sorry. So we typically see it in subdivision approval, conditional use permits, rezoning, things to do with land use. It does not apply to legislative decisions. For example, your budget approval, setting policies, making code amendments, those are not going to require quasi-judicial hearings. Dave, would you like to introduce? Yeah, go ahead. Oh, absolutely. Anybody else need one?
So I first came in contact with quasi-judicial proceedings as an assistant county attorney in about 1993, because 1993 was the year that the Supreme Court Florida said that local governments acting on these types of applications, zoning applications, change of use applications, those proceedings were now going to be quasi-judicial, which makes all the elected officials sort of like judges, acting as a body. Oh yeah, thank you. Sort of like judges. And so, to be quite honest, most elected officials didn't like that much. I'm sure you've gotten accustomed to it now, but they didn't like it much. Because the attorney would say, well, this is a quasi-judicial proceeding, you got to do this, this, and this. So one time in a county north of here that has did not have, somewhat like our county, the county commission got so sick and tired of its attorney saying quasi-judicial that they made a motion to the attorney to never say those words again. Okay, so what is it? Well, first off, you get a zoning application, and I'm just going to use an example. It's not any city here. But so you get the application, it goes to somebody on your staff. Of course, nowadays, even 20 years ago, you need to have someone either on contract or on the staff who's got a land use planning background. This person is the stuckee who's going to prepare the staff report once the developer comes in with an application. The developer is after two things, an approval, and really they want the code language that they have to comply with to be clear. They don't want it to be fuzzy and ambiguous. So you have that situation. So the key thing about, I think the next thing we're going to talk about is competent substantial evidence. The key thing about competent substantial evidence, it starts with the government's staff report, because it's based on what the application is and what the developer's asking to do. You want to go to that slide?
Yes.
Okay.
All right, so you all in those situations, commissioners that are here, staff, this portion of it applies a little bit less to you. You all are acting as a judicial body. You are taking a set of facts and applying your code to it to determine yay or nay, grant the permit, don't grant the permit. And the reason that we call it quasi-judicial is because some aspects of it are very similar to a judicial body, and other aspects, I'll get a phone call from someone being like, why don't they have to follow the standard evidence procedure? And it's because it's quasi-judicial. There are some things that do not apply that would apply in a court of law. So what Dave had started to discuss is that you all are only going to be able to consider competent and substantial evidence, slide. And then Dave is going to speak as to what is competent and substantial evidence on this side of the piece of tape.
Thank you.
You're welcome.
So let's talk about a few examples of what could be competent substantial evidence. Okay, so Scott Walker mentioned the cement plant case. The cement plant, which is out on County Road 235 north of Newberry, the application was submitted somewhere in about 1994, 95, and so it was submitted to the county. The county, I happen to be the assistant county attorney, and I didn't know about it. I read about it in the paper, and I came in and asked my boss, do you know about this cement plant? It sounds like a really big thing. And I'd only been there a couple years, and she said, no, I didn't know anything about it. So I called the land use planners for the county, and they asked them, what's this? This looks like a big deal. And we haven't heard about it. We're your attorneys. And they said, well, we were trying to keep it secret because it's a big economic development issue. But take it. So, okay, this thing queues up to a big quasi-judicial hearing. And a lot of citizens came, some against it, some for it. Is it quasi-judicial? Is it competent substantial evidence for somebody to take a big bag of cement, put it on the lectern, and slap it 3 or 4 times so that dust comes out of it, and say, cement plants cause a lot of dust? Probably not. The bag of cement caused a lot of dust when it was beat on, but maybe the cement plant won't or will not. It could. And then the second thing is, what does compatibility? You're going to hear a lot of things about compatibility. What does it mean? Okay, here's an example. Does it help if your staff planner gets up and says, well, this use is compatible with all the surrounding uses because I said it was compatible with all the surrounding uses? The because is the key word here. It should be because I've got these maps and I've got these pictures of what the surrounding uses are, and this is why it's going to be compatible. And if it's not going to be that compatible, to have some harmful effect on the neighbors, we're going to try to minimize that effect by doing this. Okay. So once you get past that situation, you get into your staff presentation, and then you have all these procedure rules that we're going to go over. That's the reason that most times elected officials get upset. Okay, so here's an example. In 1996, we had the start of cellular communications. And what does that, how did you do that? How did they deploy all these communications? And we were getting, all the local governments in the United States were getting applications for cell towers left and right because all the wireless carriers were trying to deploy their services, and there were a bunch of them. And so those kind of hearings provoked some people. They were going to say, well, we don't want this big ugly thing near us, right? Okay, or it's going to cause, the communication technology is going to cause us an illness. And so none of that is really competent, substantial evidence. So actually the first case we had, we got, we had a hearing. Some people showed up at the hearing. This may be familiar to you all. And they said, we don't want that cell tower over there because we have this farm-like, these lots out there, and it's really beautiful out there, and we don't have a big cell tower out there. And the county commission at the time voted to deny the application. And so I was assigned the duty of defending the county, and the first thing I did was start to look through the record to see if I had any of this, because look, if somebody sues your city for your denial of a zoning application, it goes to court, but it doesn't go to court in the format where people can present evidence. It goes in court, to the judge, where the judge looks at the record before you to see what evidence was in the record to support the governing body's, the county or the city's decision. And so you look and see who testified and what they said and whether or not that is something you think is correct. So when I got in that position, I start reading through that record, and I'm looking at everybody's comments, and I'm trying to come up with some competent, substantial evidence to support the board's denial. As it turned out, the answer from the judge was you didn't have any competent, substantial evidence.
You all will questions now or at the end?
At the end, okay. Yeah, okay. Okay, so you have that situation. The judge then says, county, you didn't do a very good job on this. You have no evidence in the record, and therefore I'm going to order you to issue the permit. Well, at that time, it wasn't too clear that the judge couldn't do that. It's really clear now that the judge cannot do that. The only thing the judge can do on this kind of a proceeding is eliminate the denial, denial by the city or county, and send it back to them for future proceedings, okay, for another proceeding. So the developer went in, wanted the cell tower, didn't get it, now has to go back in front of the same body. So I'm looking at this and I'm saying, well, what can we do? Because I was like, I was like a squirrel trying to find an acorn in that record, and I couldn't find it. And so what do we do? And so we came up with the idea to do simulation photos of cell towers. So we'd find out how tall the cell tower was, and then we would get a picture of the cell tower from 4 to 6 different view sheds at different distances. So we could present to the county commission what it was going to look like. And everybody would see what it was going to look like. And that was considered competent, substantial evidence on several cases after we did that where we got challenged. By the way, I was asked at least one time when I was county attorney that I recall in one of these really intense hearings to answer the question, do you have competent, substantial evidence? What is it? And the attorney's not the judge, the attorney's the advisor, and so I answered with that definition. Everybody's eyes glazed over, and they weren't too happy with it, but I didn't want to substitute my opinion on the evidence for the governing body that's now in a quasi-judicial position, making a quasi-judicial decision. Yeah, ready for the next one. Sure.
Can you mind two more quasi-judicial slides? We're just trying to get to the end of the section.
Okay.
It is now?
So you act like a judge, staff prepares a record, and yes, throughout the state of Florida, and the state of Florida is not the only state that did this. Of course, you know where it came from, Oregon and California. And so, but it came to us and we had to deal with it. Recently, I was asked to advise, to consult with the city attorney, not a city attorney for any of the cities here, not a city attorney for any of the cities in Alachua County. But what happened was, it played out like this. They had an application to do zoning change type action. They had an application for a development plan approval from a landowner, and the landowner wanted to develop the land. They had some language in their code that was fairly clear, but the city council members didn't like that language much. Even though they'd adopted it a few years before, they decided they didn't like it because they didn't want to approve this application. So after the other thing they didn't have in this particular case, and this was only 2 or 3 years ago, they did not have a staff report with a land use planner and any other government expert providing testimony, like engineers, environmental people. They didn't have any of that. And so they basically denied the application, and they got sued in court. And that's when they asked me, what should we do? Well, I was pouring through a record like I used to, trying to find that competent, substantial evidence. And, you know, I couldn't find any. And I said, by the way, I think your code says you had to approve this, and you'd be better off just letting this one go and approve it, and change your code if you don't like what your code says, because that's what the criteria is. So that's where we, and I don't know where that ended up, but actually they did go in front of a judge, and they presented really good, the city presented a really good argument and lost, because it wasn't there. There was no competent, substantial evidence in the record. And so I haven't checked to see what happened, but I think the litigation went on a while later.
They just settled it.
Oh, they did?
Just went to mediation.
So it went on about 3 years.
Yeah.
Did they approve the application?
They did not approve it. So the epilogue of the story is that the city, it came back to the city, and the city denied it for a second time. They were going back to, they went back to court. The judge sent them to mediation, and they just signed a mediated settlement agreement, and I think it has to be adopted by the city yet. But the epilogue of that is when you're in particularly if it's a very complex situation and you got people on both sides that are, you know the kind of cases that you have when you have a hot zoning matter or a hot land planning type situation. Because when you drive up in the parking lot, there's 40 cars out there. Okay, something's really happening tonight that it's a hot issue. And so in those instances, that's when you really got to make sure you got your staff planner there, or you got a contract planner. And we talk to Allison McGrath a lot. She does a good job. She does the analysis, she does the staff report if you don't have a planner. But as Dave is saying, it's critical to have planning staff in the mix, because if you don't have it, you're that squirrel looking for an acorn that's buried under, 1,000 hay needles, and it's just not good.
And you know that this kind of litigation is just good, clean fun for attorneys. And so the best thing, I used to tell the county commission frequently that if we had our hands dirty on something, we should stop, restart, and do it right. And that would help. I guess there's one more slide here. I can comment on that too. The answer is that you shouldn't do that. Now they can come, these ex parte, they're out of your hearing. You know, you have a hearing, you convene the hearing, and everybody can speak, everybody can hear what you're saying. These are conversations that happen about this zoning application out of that hearing. They're called ex parte communications, and they're not allowed. And so what you do is you can get them two ways. You can get oral, telephone call. The other way you could get them is a document that somebody sends you. If you get a document that somebody sends you, then you have a record of what it was. You can put that in the record. And but if it's an oral communication, and I don't know whether you do this with your cities, but what we used to do at the beginning of these hearings, we'd ask all the county commissioners, have you had any of these out-of-court hearings? Because if we get caught that they have afterwards, we're going to be in a situation we're going to be going back and forth to court to resolve it. So you want to take questions on this topic now? What happens if I decide ahead of time what I'm going to vote? Oh, yeah. Well, you're probably doing that when you're reading the staff report for the first time, because you read the staff report before you go to the hearing. But keep an open mind going into the staff report. But the bottom line is you shouldn't announce any decisions to after you've heard all the evidence, because this is a judicial proceeding. And yeah, you shouldn't. We're going to talk a lot about personal interest in the outcome and ethics, so I want to address that. But you're in a it's really an odd position for an elected official to be in. So, but it's what we do in Florida. We have no choice, and the more efficient the proceeding is, you got to let everybody talk too. And if somebody comes, you also can't. One time we were having a hearing on a quasi-judicial zoning application for a planned development. It was about 10 o'clock at night. We were in the county commission room. Sometimes the citizens should show up, they'll have an attorney. This time they had an attorney who was also a land use planner. That's a unique combination of skills. So it was about 10 o'clock, 10:30. We were still going. We had a deputy sheriff there, and the deputy sheriff thought, well, I'll go down and lock every door but one to access the county commission meeting room, and for security reasons. At the same time, that witness attorney had decided it was time for him to go out and have a smoke. And so he was out there, and it's when the door was locked, and so he couldn't get back in. And he's a citizen. He's representing the citizens who were there opposed to something. Nobody knew this happened because we thought he just disappeared to Leon's or something. And we weren't going after him. But it was over Thanksgiving. I started getting these emails on Friday about this problem with this guy not being able to get back in the meeting. So what do you do with that? Well, first off, you investigate it, find out it was true. I found it was true, so I called the applicant's attorney who had received a successful approval, and I said, here's what happened. We're going to have to redo this. And the next meeting the county commission had, I told them we got to redo this because we didn't comply with all the requirements. It had to be an open meeting. Everybody had to have a chance to speak.
So I think the way we're going to do this for questions is if you can ask me, I'll repeat it into the mic because folks on live stream might have the same questions as y'all, just so that we're not reinventing the wheel. You had a question first.
I'm looking at competent and substantial, and particularly as it relates to citizens giving testimony.
Sure.
Just looking at some examples, what are some examples of competent and substantial testimony from citizens?
So, yeah, so you're referring to whether or not there'll be an expert, and I have, unfortunately, a cop-out answer for you. A lot of our cities are dealing with that issue right now, and we're getting close to rendering a written opinion to all of you about that, because we know that that is an ongoing issue. Mayor Marlowe's smiling at me right now, because he is one of my people who has asked for it. So that is the answer to that, but Dave can provide some insight. Just keep an eye on your emails, because we will be rendering a written across the board what is an expert when it comes to citizens. But Dave will be happy to provide some insight right now.
The best evidence I've seen by citizens is when they say, because this, this, and this. And for example, if they say, this is going to have an adverse effect on my property. Why? If they have pictures, if they have some sort of an analysis, that is how they substantiate their testimony. So it's got to. So if you're talking to somebody that's going to come in and present that kind of testimony, that's the advice I would give them. You just can't go in and say the tower's too big and ugly. You got to prove it's too big and ugly. Well, then we helped them out with our simulation photos there. But the other thing I don't think we mentioned about these proceedings is if the applicant has an attorney and a citizen gets up and testifies, you got to give the applicant's attorney a chance to cross-examine or ask that person questions. Likewise, if it's the other side testifying, the government could ask questions. And I'll be quite honest with you, I've never seen that have a positive impact on the proceeding, and I've been in too many of these things to count. Because what happens when attorneys start acting like attorneys in quasi-judicial proceedings, the elected officials, they start squirming, they don't like this, and it adversely affects their case. So the smart attorneys who do this, if they ask any questions at all, they don't ask very many. And it's not a judicial proceeding, it's a quasi-judicial proceeding. And it is bad. It produces usually a bad outcome for their side.
The question that's before us right now is, how do I know if this person is giving expert testimony? I'm a citizen, and I've been elected. I'm a commissioner now, and I'm sitting on the dais. I'm a planning and zoning board member, whatever it is, and I have to make my decision based upon the testimony that is coming before me, and I have to decide if this opinion testimony is valid. Should I consider the opinion? Should I strike it in my mind? And that's a pretty fine legal point that you have to get to. And the answer to that is that there are some people that are experts because of their educational background, and typically they have initials after the name, like AICP, that's the American Institute of Certified Planners. A lot of what we're dealing with is planning issues, and if you see somebody like that, or if you see an engineer that comes before you, a lot of times there's different types of engineers. Those are kind of easy to marker, and usually those experts get up and say, well, I've been an engineer doing civil planning work for 30 years with such and such company. All right, that's an easy one. We know that person has an expertise, has done this many, many, many times. Now, your question is, what about the citizen that gets up and says, hey, I'm going to give my opinion testimony on this issue? Well, you can't just discount that at that point, because that citizen, what if that person's been in this industry or this science for 30 years? And maybe they don't have the educational training, and maybe they haven't had the designations that, American Institute of Certified Planning. But that doesn't mean, and what I like to say is, you don't leave your common sense at the door. When you come in and you sit down and take your seat to make a decision, you listen to what is being said and why this person has, as Dave just said, the why. Why do you have the ability Well, for 30 years, I've been dealing with this particular issue. If I was talking to Ross and Ross Ambrose, commissioner up in, now our mayor pro tem, up in High Springs, and it had something to do with porta potties, some issue out there, well, I would think that based upon his background and expertise, he could tell us something about the science, the industry, the business of porta potties. You know, or if it has to do with wastewater. And he's got background and training in that would be interesting to hear. I was in court on a big case. We were doing ground penetrating radar to establish whether there were voids and we're permitting. I was against permitting of a construction demolition debris landfill. And I had a guy out of Tampa. His name was Windshower. He's a big Austrian dude. And I'm qualifying him as an expert. Well, Mr. Windshower, you have testified in the state courts of Florida. Tell the court how many times you've testified. Never did. Never have. And of course, you know, as a young lawyer, you're supposed to know the answer to these questions. Is one of those moments in my experience of, okay, well, how about federal courts? Nope, never did. And the judge didn't like our case. The judge was, and the judge looks over at me and kind of smiles. Gotcha. You're going to have a time getting him qualified as an expert. I said, well, how about administrative hearings? Certainly you've testified in administrative hearings. Nope, never have. And I'm like, well, other states, have you testified in any? Nope, never qualified as expert before. I'm thinking, Scott, you should have asked those questions before we got to trial. So then I went into his education. How long have you been doing this work as a geologist? Well, I went to University of South Florida and I got my master's degree in geology. Then after that, I was a partner in this firm that does ground penetrating radar, and this is how we do it. I produce these reports all the time. This is my business. And all of a sudden he gets a call. Joe Robbie Stadium had a void that opened, a sinkhole that opens up. I said, Judge, I gotta speed up with what we're doing here because I got to get down to Joe Robbie Stadium, and they need some help. The Dolphins got a game this weekend. I got to get down there. All right, now he's an expert. You know, look at what his background and look at all of that. And he got qualified as an expert. The next thing that he said is, Judge, when do we break for lunch? Because I'm getting kind of hungry. and it tickled the judge. The whole case turned around. We won the case because of Bob Windshower and his testimony. But just because somebody hadn't been qualified as an expert previously, just because they don't have the letters after the name, that's a trap for the unwary. And you could, if you exclude that person, then you may be incorrect in saying, oh no, we're not going to listen to your opinion and testimony. So there's a standard, and as Danielle said, we're going to come up with definition of what an expert is. We're going to put that in the practice and procedure manual for quasi-judicial for all our cities. And I think what I'm going to do is when I'm there, I'm going to read that into the record. This is what an expert is. Under Florida law, there's a little paragraph definition of what that is. And that I think will help you in making your determination of what an expert is and what an expert isn't, and whether you should consider the opinion testimony or not. So that's kind of our game plan of how we're going to handle that. It's a great question. I'm glad you asked it, because it's one of those questions that is coming up in all our cities right now. How do we handle this thing? So that's...
Can you give me a second just to explain also? I'm concerned about the impact on the citizen that has a concern about an issue. One example would be we have a peanut plant inside of Williston that is impacting a lot of citizens along that specific road. Now, there hasn't been a real issue with that in terms of zoning or whatever, but there may be. And the concern that I have is that those citizens don't have the ability usually to take readings to determine if it's above the decibel level. My concern is is there an impact on citizens, can there be an impact on citizens where they don't necessarily have the tools to make a, I guess you'd call it a substantial determination. But the fact is that they are impacted based on something like noise level or whatever. At what point can citizens actually come in and have a complaint about something going in or something that's going to be done in a specific area?
So we're going to give him the award of best questions of the night so far. Really interesting question, because Florida law has a standard on noise. So if I'm a police officer, and there's a case came out, I think it's about 2 years old now, it's a Supreme Court of Florida case where an officer heard the noise, felt it was over the decibel limits. I think it had to do with, boombox type noise in a vehicle. And he said, look, I'm going to write you up under the noise ordinance, and that went all the way to the Florida Supreme Court. And they said in that instance that we don't leave our common sense at the door. That officer knows what noise is, and it was obviously over the noise statute or the ordinance, and therefore the officer had the right to cite that person. So there's two ways that you can approach that. One is what is the impact to the citizenry? If I'm sitting on the dais, I'm going to let that come in, because where you get into trouble is there's two things. There's procedural due process and there's substantive due process. And the easiest way to trip yourself up or your city up is to disallow procedural due process to happen. Look, citizen, you think it's noisy, we're not going to hear from that. You don't have the expertise to say that. So the more the information comes in, the better. Now, the question that you also have is, how do I consider that? So I think using the plainly audible standard, which is what was enunciated in the Supreme Court case, using that standard, is it plainly audible? Is it impacting the citizenry because of what they're hearing? Okay, that's one way of doing it. Second way of doing it, we're permitting another construction and demolition. This time I was on the permit side in Inverness, getting a construction and demolition debris landfill permitted. So I had a noise expert, never testified before, but he did a wonderful job, and he did a wonderful, he did drone views of the site and the facility. We superimposed what was going to be on the site. He started the tractors and all of the equipment for the facility down in the site that went to City Hall, measured the decibel limits from that point and created a report for that. Now that's a very scientific, he never testified before, but every day in his normal job existence, he would go to sites where bands are setting up, and he would test the decibel meters. So his practical experience carried the day. He didn't have a sound engineering degree, but he was very, very used to doing that kind of work. And of course, his testimony was accepted as an expert in that instance, and it carried the day for us as far as permitting that site, because he measured, if we turned out that the highway created more noise than what the facility was going to create. So that's the answer to your question, hopefully. Sure.
Mark, you had a question?
Yeah, so it really can't be honest to him, but you answered a lot except for my question is, when we do this, reading the definition, if specialized training or knowledge is required. So there's a lot of ifs in here, and Scott, what I'm asking is, and you've been in the meetings with us and give a lot of great information, when they come before a subdivision or something that they don't like, they get to come up over and over, and they want to give us, there's nothing in their preview that they're experts in anything except they don't want. but we still have to listen to it to the point where over and over, and you've been there, we just went through this over a subdivision. So my point is with that particular definition right there, a citizen comes in, they have none of that.
Can I add on to his question here, because I think what Mark is getting at is if you allow public comment before you allow the commission to ask the competent and substantial evidence bearers, are you swaying the commission away from competent and substantial evidence towards just opinion?
The question is, should we allow citizens to come up, you know, and they kind of go over the same thing over and over and over again. And it's tiring. You know, you're getting on 11 o'clock at night and you've heard the same thing, and it's just getting to be the same issues, same thing. Okay, we understand. And you can't raise your hands, show of hands how many are for it, show how many hands are against it. We had one where there was the blue shirts and the red shirts. All the red shirts sat on this side, all the blue shirts sat on this side. And the red shirts were for it, the blue shirts were against it. So you could pretty much, as a commissioner, count how many people were for it and how many people were against it. And it was actually pretty even between the blues and the reds. And so it was a little easier to understand. And one of the things that the mayors do, that I notice, is they'll say, look, you've covered this subject matter 3 or 4 times. Everybody's done that. It's getting on at 11. We're gonna sit here. We're gonna listen to it. We're not gonna shut anybody down. But unless you have something new to add, you know, we know that the blues don't want it. We know that the reds do want it. And these people up here have to make a decision on that. But unless you're going, and that does sometimes really help to restrict. What new do you have to say, you know, this is the thing that, you know, nobody's talked about this yet. Now, Jordan's mayor up in Newberry. He's on the 2nd floor up there in the gallery. And his second question was that if we allow the citizen comment, then, you know, are we influencing the decider on, and they may say they're an expert. And the point that I would make is more, what happens if you restrict it? You're in much more dangerous territory as a commissioner or as a mayor or as the planning and zoning board if you say, no, we're not going to hear this. I would let it in and not be restrictive. If somebody just wants to get up and wants to say, this is going to affect the value of my property, I live right next door to this property and it's going to really impact me on my traffic, it's going to impact me on my, you know, the visual side of it and all that. Let those people get up and say. And if it is affecting your property in such close proximity, then that does raise to a higher level in your consideration of should I make this decision this way or that way. That you really have to listen to that. One other thing on that issue is that, Mark, you got a nice, beautiful truck. And I bet you if I asked Mark, what's the value of your truck? If you wanted to trade it in or you wanted to put a for sale sign out, what's it worth? You know what the value of your property is. And that's what Florida law is. If you consider what is the value, the fair market value, because it's your property. Now, if it's affecting your property in such close proximity, or it's your property that is getting developed, then the law allows you a little latitude there as to talk about what values are. So if somebody gets up and says that, okay, what's your dog in the fight? Well, I live right next door. All right, that's an important piece of the puzzle. Now, as the lawyer, what I would do, if somebody was touting themselves to be an expert, I may ask them some questions. I'm very used to doing that in court. So I might ask, do you have any specialized training? Do you have any specialized experience? Did you ever testify before? Nope, first time ever. You know, but you might ask those questions. And of course, the attorney that is on the applicant's side, perhaps, and that's why we always say, do you have any cross-examination? Do you wish to cross-examine the witness? And so that's kind of how I think you handle it. And if it gets too late, you might bump it to another day. I know, Dave, you've had that go well into that. We fought each other on the Pennsylvania Real Estate Investment Trust for a while up on 39th Avenue, Spring Hills. Okay, Janice, go ahead. Okay, hey, Janice.
If I'm voting no, how much of a reason or justification do I need to give for the record?
Great question. Janice, that's a terrific question. She's asking, she's voting for or she's voting against something. And she might be in the majority, she might be in the minority, depending on, and as Dave said just a little while ago, if it goes to court and for whatever reason on writ of certiorari, the judge reverses or remands it back to, you might see it again. So her question is, what basis do I need to put into the record? What do I need to do to support why it is that I'm voting yay or nay on something? What is it? And that also, Janice, really helps us as the attorney, because if we're drawing the resolution based upon what it is, and you specifically say, you know, we had a traffic engineer that came in and said that the impacts on the surrounding road system is going to be so adverse that it's going to create problems for the local community in this way. So I listened to that traffic engineer, and my decision is based primarily on the traffic engineer. But also, I think this planned development is too intense for the area because of this week's traffic. Maybe there's sewer and water impacts that are going to be problematic for the city. The more that you have loaded up in your decision making gives us the ability to say, okay, Janice decided in this way for this reason, and we load up our resolution with that rationale if you're on the majority side of it, because as Dave said, this is going before a court on a writ of certiorari. It's not a witnesses get called, it's not a typical court procedure. It's on the record of kind of like an appellate procedure like we talked about with Derek Foles just a little while ago. So you have to take those little nuggets, those little acorns out of the record and support your side and protect your city in that way. And so so if I hear you say, I'm going to move to disapprove this subdivision, you know, I may ask you and say, now, Commissioner Mortimer, I would like to know the basis as to why you're voting against this. Tell us a little more about that. And if I see there's a second and two other commissioners are saying, you know, I like what Janice said, I think I'm going to vote with that, you know, I think what she's saying in the discussion about the motion, then I'm going to, and if we don't have it in the record and we need more information, I might call our planner up and say, hey, can you give us some more information, a traffic engineer, some more information? You heard the motion. Why is this? Give us, you know, your report, your recommendation. It's very nice if you have an engineer that gives you a written report that goes in the record, goes up to the judge for review. All of that is what buttresses the city when they go for it or against it. That's what we're looking for. Absolutely. Tony.
Most of the time when you're addressing these issues, you've got written criteria that you have to grade it against. Most of the issues that are brought before Archer are, it's going to decrease my property value, or it's going to kill the animals. How do you justify that? I mean, just there's got to be something that they got to provide that's going to back that up. It's a statement in order for the commission to make a decision based on that.
So Tony's question is, if you have a bunch of citizens that get up,
The cell tower, or not the cell towers, solar plants, solar farms. That's one of the greatest things you hear. It's going to decrease my property value. Or it's going to kill a wildlife.
well, I think like Dave said a little while ago, how? Why? You say it's going to kill wildlife, citizen. In what way? How is it going to impact the wildlife? And if that citizen could justify it in some way and say, well, you know, I've been a solar farm construction worker for the last 10 years. I've installed hundreds and hundreds of these panels, and this is how it impacts the wildlife, and this is what happens when you, okay, well now we know something more, and tie it in to what the statement is. If it's just a bald statement that it's going to create a problem for our wildlife, well, how? How is that going to be the case? And usually those solar farms have fencing around it. They're massive arrays. If you go on I-10, you see those that go for miles now. And so now there's also data. So if you got Duke Energy that's coming in to your community, then one would hope that Duke would come up and say, well, wait a minute, we've got a wildlife expert. They've got the funding to have the experts to do that. But they would come in and they would say, this has no bearing whatsoever on reality. It's kind of like what Dave said early on when cell phone towers were first coming in. Oh, we're all going to get cancer from it. We're all going to, you know, these radio waves. Well, wait a minute. Radio waves have been bouncing around our society for 100 years now, and people, I don't believe that they're getting cancer from that. That doesn't seem to be a justifiable opinion testimony that you can hang your hat on and make, unless you're a medical doctor that has studied, you know, cancer rates as a result of radio waves on some study, I don't know. It doesn't really seem to make any sense to me, you know, from a common sense standpoint of where we're at. So affecting property values, same way. All right, where's an appraiser? Where's your, you know, hopefully the applicant is at least going to have that in place. And if you're going to contest it, tell me how this is going to affect your property values. Give that data to us. That's what we're looking for. Okay? Yes, I believe so.
Yeah, one more question.
Yes, go ahead.
With regard to quasi-judicials, I've had two glasses of wine now, which is really delicious. I was once the liaison from the town to the quasi, and was an effective party standing. And during that hearing, I was heard several times as an effective party. Toward the end of the meeting, just before the final decision was made, the other party was able to bring witnesses, offer attorney summation, etc. I was not offered to speak, although I was requested to speak. What are the rules with regard to how you must hear certain parties, especially if they are affected?
So the question is she was in a hearing where there was a hot matter, and she was an affected party, and it was going to impact your situation along with your people that you were there representing, the municipality. And it sounds to me like there should have been some consideration of a designation of intervener status. If you can show, you know, we almost never have it, but if you can show that you are specially affected by virtue of the decision that's going to be made, then you're entitled to intervener status, and you're treated like a party in that situation. So if I was sitting there and I heard that information, I would have probably said, wait a minute, she's an intervener, and she gets more time to speak and present, number one. Number two, I would let you have the arguments at the end and closing argument and that sort of thing. That would be my way of handling it. And again, what happens if you don't do that? If you don't give somebody that's specially affected that ability and you restrict it, then you get into a situation where procedural due process rears its ugly head, and you might, if you decided to take it up on appeal for a writ of certiorari, the chance of that getting overturned on procedural due process basis is much, much, much higher. Dave's going to add to it.
The way I'd approach that is, first off, I would simply say to the county commission, to the city council, in these proceedings, more evidence is better than less evidence. You haven't made your decision yet. Hear everybody that wants to talk. The worst thing you can do is shut somebody down.
100% concur with David's opinion. You know, you won't get wrapped on the knuckles by the judge if you allow more due process to occur. That's not going to get you in trouble. Where you get in trouble is where you don't get allowed to speak on an issue, and then you got trouble.
In this case, it was staff that was holding what wasn't judicial. It wasn't a magistrate or a judge.
Right.
And I was endeavoring to educate the staff members that was holding this. Presiding as chair on proceedings. This was a county issue.
Yep. Yep.
So, yes, it was definitely riddled.
I'm pretty sure now I know exactly it was a hot issue, and it's coming to a beautiful conclusion. Thank goodness. Beautiful.
I told him when I retired to blame me when things like this happen.
All right, I think we're going to the next section.
Kirsten and
All right.
I'm going to sit. Perfect. All right, so we are going to start talking about our next section of the presentation, which is how do we have all of these rules for ethics? Where do they come from? Why are they important? And who is responsible for making sure that you all follow them? Obviously, there's more than one place where the law comes from. I'm sure that you've each heard your city attorney say that this is statutory, this is involved in case law, there's constitutional issues. So nothing's ever as cut and dry as, here, look at this one piece of paper, and this is all the law that you need to know, and that's that. So we have constitutional requirements that we have to follow under Section 8, Article 2 of the Florida Constitution, which requires public officials to act in accordance with certain ethical standards. We also have a code of ethics for public officers and employees, which is available to all of you. It's online. It's a pretty thick booklet of information that you can access. And if you reach out to your city attorney, we'll be happy to provide it to you if you're looking to read a big, thick book full of rules that are written in a confusing way. Yes, there is a searchable feature as well, which we use quite often. There's also criminal law statutes which govern your behavior in these ethical ways. So, for instance, you'll see later on some of our examples. Violations of ethical laws are can not only result in your removal from office, they can not only result in you being ineligible for office, but they can also result in criminal procedures. Jail. For lack of a better term. So there are several really serious consequences. And then also we have common law, which is what we colloquially refer to as case law, which is just where courts have determined more specifically what the law means in certain circumstances.
All right, so we have some resources for when you have any questions. The first one should be your city attorney. If you have any question, just call the city attorney's office. That's what they're here for. They've been doing this, as Scott said, 40 years. Mr. Folds, another, was that 50? 56 years. So city attorney's office, first call. There's also the Florida Commission on Ethics. They do written opinions as well. They also do informal opinions. They also will help you out on the phone. They'll give you basically a customer number, give you a very informal opinion that's really saying, look, here's a few ethics rules, go look at these, it's going to give you the answer. We can't tell you for certain, but those will give you the answer for you. So the Florida Commission of Ethics has a lot of different avenues to help you out. And then, like I said, City Attorney's Office, so give them a call whenever you have a question. And like I said, the Commission on Ethics, they do advisory opinions, they also investigate complaints and make recommendations. So remember that, citizens are going to keep you in check, so just make sure you're calling if you have questions, following the rules as best you can. And of those 230 complaints, 109 were dismissed for a lack of urgency. One was dismissed because the public interest would not be served by proceeding. 97 were ordered to be investigated, and 31 of those are pending a legal sufficiency determination as of December 31st. So. Well, no, and that's an interesting one, though, because that is the different types of complaints. So as you can see, misuse of public position